Hi everyone. We're in week 6, getting near the end. I know you're probably feeling a lot of pressure to get your work in, and I know you have other courses to consider, or at least you probably do. So I'll keep this as brief as possible, but I want to give you a little bit of an introduction into the substance of crime. Probably why you signed up for this course in the first place and why you're majoring in criminal justice related things. So let's talk about what a crime is. How do we know that a crime has been committed? What distinguishes criminal behavior from all other kinds of behavior? You see somebody walking down the street, that person is minding his or her own business. He or she turns a corner. Has any criminal behavior occurred? Not from what I just said. Now you see a person walking down the street. He or she passes another person and in passing bashes that person on top of the head with a baseball bat. Now has any criminal behavior occurred? Of course it has. Now why do we say that someone who uses a baseball bat to bash somebody else on the head has committed a crime? Well, we say that because that person has violated some of the social norms that we hold dear in our society. We don't approve of randomly bashing people on the head with baseball bats, do we? No. Now, maybe there sometimes is a good reason to do that. Maybe the person is approaching you with a gun, and in order to avoid being shot, you bash them on the head with a baseball bat. That's a whole different story, which we won't get into this week. What we will get into this week is what are the elements of that crime that I just described? What is the actus reus, A-C-T-U-S-R-E-U-S, nice little Latin term that we lawyers like to throw about to show that we have actually been to law school. That actus reus means bad act. What's the bad act in the crime I just described? Well, it's bashing somebody on the head with a baseball bat. That's element 1. The second necessary element in order to prove that a crime has been committed, a crime and not just an accident, is what's called the mens rea, which is the bad thought, the evil thought, or really the criminal intent. What was the criminal intent in the act I just described? Well, it's the intentional holding of a baseball bat and using it to strike somebody on the head. Now, you can never really read a person's mind, but you can infer backwards from their act that they had a bad intent in mind when the act was committed. So the two essential elements that a prosecutor must always prove in convicting somebody of a crime are actus reus, the bad act, and mens rea, M-E-N-S-R-E-A, another Latin term, the criminal intent. So, in this module, Module 6, you're going to be reading some of your readings and will introduce you to these sorts of things that I've just mentioned, the elements of a crime and the procedures that it takes to bring a bad act, something that we've labeled a crime, into court and actually try somebody for the bad act. And by the way, do you see my Band-Aid? It's Teenage Mutant Ninja Turtles, left over from when my grandson was here. And of course, just because I love the Teenage Mutant Ninja Turtles, who doesn't? Anyway, to get back to the subject at hand, sorry about that. We have to talk about criminal procedure. What happens in a trial? Well, one of the things that will sometimes happen in a criminal trial is that one or both of the parties, not usually both, one or the other of the parties, either the prosecution or the defense, will request that the court change the venue of the trial. That is to say, move it from the county or city in which the crime was committed, which is the normal and logical place for a crime to be tried, to some other locality, usually because either the crime is too well known or the perpetrator of the crime is too well known in the community where the crime happened, or there's been a lot of publicity and you want to take it out of that place where everybody knows about this crime and try to move it to a place where it isn't so well known. One of the actual topic of your discussion board this week is for you to find a criminal case, not a civil case. Please remember this, a criminal case in your home state. If you can't find one in your home state, use another state, in which a motion for a change of venue has been made and the court has ruled on it. Now, this is a little bit tricky because what you're actually going to find are not case reports of the trial, probably, because usually those are not readily available to the public. But what you're going to find instead is a report of an appeal from a trial judge's ruling on a motion for a change of venue. So the case reports you find are almost always reports of appeals. Now, you remember our court structure. We have a trial level. Above that is usually, but not always in the state system, an intermediate appeals level, and above that is the highest court in the state. Usually it's a tri-level court system. Now, in your state, there may only be a bi-level, and maybe a trial court, and then the ultimate appeal to the highest court in the state. In the smaller or less populous states, very often you only have 2 levels. So it doesn't matter how many levels there are. What matters is that the reports that you are likely to find of motions for changes of venue and rulings on them are the appeals level. So that's fine. Read those. That will take you, when you read those reports, it'll take you back into what happened at the trial. And your discussion board asks that you talk about this case in which there was a motion for a change of venue and discuss whether you think the motion should have been granted or should not have been granted and why you take the position that you take. Doesn't matter what your position is, as long as you can defend it with some logic and evidence. Then you also have this week a short paper that's going to be due, and that short paper is an entirely different subject, but one that's related, and that is a topic that comes up at the end of a criminal case when the defendant has been convicted. Sometimes courts are bound by what are called mandatory minimum sentencing standards. And that is to say, the court, the judge, has no discretion or very little discretion on what kind of sentence to impose upon a defendant who's been convicted of a certain crime. The state legislature has, in those instances, mandated that people convicted of crime A, for instance, be sentenced to X number of years in prison, or perhaps a range from X to Y number of years in prison. And the judge has no discretion on lowering that number or raising it or shifting the sentence to something that's not a prison term. There's a mandatory minimum number of years that the person has to be sentenced to prison. And then in some other states, and sometimes also in the federal government, we have, in addition to mandatory minimum sentencing, or instead of, we have what are called sentencing guidelines, which give the judge back some judicial discretion and allow the judge to be guided as to what might be an appropriate sentence for a particular crime, but not be bound by that guide. Be able to, in other words, exercise some judgment, which is really kind of what we want judges for, isn't it? We allow the judge to exercise judgment in determining what an appropriate sentence would be, not for a particular crime necessarily, but for a particular crime as committed by the particular defendant who is being tried in that particular trial. That is to say, we allow, when we have just sentencing guidelines, we allow the judge to decide what an appropriate sentence for this defendant would be. Not all defendants who've committed crime A, but this defendant who has been convicted of committing crime A. So that will be your topic for your short paper. Your topic for the discussion board, as I said, is the case in which I lost my train of thought. Case in which a motion for change of venue has been made and either granted or denied. And I look forward to hearing what you have to say about both of those things. They're both very important in a criminal trial. Very often motions for change of venue are made. Not so often they're granted. They're actually granted on a very rarely. And And then in your short paper, you'll get to discuss the meat of sentencing. Should a judge be able to exercise judgment, or should the legislature instead have the power to impose certain sentences on certain crimes and take that discretion away from a judge? I'm looking forward to hearing what you have to say about it. And you'll see in my replies to your discussion board posts kind of where I stand. But until then, I'll wish you a good week and talk to you later. Bye.